Right Honourable Speaker, I would like to thank you for this opportunity. This is a report of the Sector Committee on Legal and Parliamentary Affairs on the Judicature Amendment Bill 2023. I have with me a copy of the report and copies of minutes, which I beg to lay on table. Madam Speaker and members of the House, on Wednesday, 22nd November 2023, a bill entitled the Judicature Amendment Bill 2023 was in accordance with Rule 128 of the Rules of Procedure of Parliament, read for a first time and referred to the Committee on Legal and Parliamentary Affairs for scrutiny. The Minister has already read the object of the bill. Really, it is to give effect to Articles 130 and 134 of the Constitution by prescribing additional numbers of judges to the Supreme Court and justices of the Court of Appeal. The bill further empowers Parliament to increase both the number of justices of the Supreme Court and justices of the Court of Appeal to such higher numbers as Parliament may by resolution prescribe. The committee adopted the qualitative method in interacting with stakeholders, whereby the committee only invited persons and entities whose mandate is connected to the exercise of judicial power in Uganda. We met the following entities: Ministry of Justice and Constitutional Affairs, the Judiciary, the Law Development Center, Uganda Law Reform Commission, and we also received written submissions from Judicial Service Commission and Uganda Law Society. Justices of Court of Appeal and Supreme Court. Article 129 of the Constitution of the Republic of Uganda provides that judicial power in Uganda is exercised by the courts of judicature that consist of the Supreme Court of Uganda, the Court of Appeal, the High Court, and such subordinate courts as Parliament may by law establish, including Cadi's courts for marriage, divorce, inheritance of property, and guardianship as may be prescribed by Parliament. Article 129(2) designates the Supreme Court, Court of Appeal, and the High Court of Uganda to be superior courts of record. Article 1(3) of the Constitution provides for the Supreme Court of Uganda and its composition and requires that the Supreme Court is composed of the Chief Justice and such other numbers of justices of the Supreme Court, not less than 6, as Parliament may by law prescribed. And it is reproduced saying the Supreme Court shall consist of A, the Chief Justice, B, such number of justices of the Supreme Court not being less than 6, as Parliament may by law prescribe. Article 134 of the Constitution provides for the Court of Appeal of Uganda and its composition and requires that the Court of Appeal is composed of the Deputy Chief Justice and such other numbers of justices of the Court of Appeal, not less than 7, as Parliament may by law prescribe. And it reads as follows: the Court of Appeal of Uganda shall consist of the Deputy Chief Justice and such number of justices of appeal, not being less than 7, as Parliament may by law prescribe. So Articles 130 and 134 prescribe the minimum number of justices of Supreme Court and Court of Appeal being 6 and 7, respectively, and delegates to Parliament the duty to prescribe the total number of justices of the Court of Appeal and Supreme Court by law. As commanded by Articles 130 and 134 of the Constitution, Parliament enacted the Judicature Act, Cap 13, to generally provide for matters relating to the judiciary, especially the composition of the Court of Appeal and Supreme Court. Section 3 of the Judicature Act gives effect to Article 130 of the Constitution and prescribes the composition of the Supreme Court to be 10 justices and the Chief Justice, making a total of 11. Section 3 is reproduced below, saying the Supreme Court shall consist of the Chief Justice and 10 justices of the Supreme Court. On the other hand, Section 9 of the Judicature Act gives effect to Article 134 of the Constitution and prescribes the composition of the Court of Appeal to consist of the Deputy Chief Justice and 14 justices of appeal, making a total of 15. It's reproduced as the Court of Appeal of Uganda shall consist of the Deputy Chief Justice and 14 justices of the Court of Appeal. Now, when we go to your analysis of the provisions of the bill, this part examines the amendments proposed by the bill and its legality and effect and effectiveness to deal with the mischief it intends to cure. The committee makes recommendations on each of the proposals in the bill. 5.1, Clause 1, increase in the number of justices of the Supreme Court. Clause 1 of the bill proposes to amend Section 3 of the Judicature Act by substituting it for the following: that the Supreme Court shall consist of the Chief Justice and be 20 other justices of the Supreme Court, or such higher number of justices of the Supreme Court as Parliament may, by resolution, prescribe. Section 3 of the Judicature Act currently provides as follows: the Supreme Court shall consist of the Chief Justice and 10 justices of the Supreme Court. So it is Chief Justice and 20, that's what's being proposed. What is currently there is Chief Justice and 10. The amendment to Section 3 of the Judicature Act has the effect of increasing the number of justices of the Supreme Court from 11, including the Chief Justice, to 21 justices, and B, changing the mode of prescribing the number of justices of the Supreme Court from prescribing the number by legislation, as is currently the case, to prescribing the number by resolution of Parliament. The Ministry of Justice and Constitutional Affairs and the Judiciary justified the amendment on the need to effectively and efficiently deliver justice to the people of Uganda and to deal with case backlog in the Supreme Court. The committee was informed by the Ministry of Justice and the Judiciary that the intention of increasing the number of justices from 10 to 21 is to create 3 panels in the Supreme Court instead of the current 1 panel. These panels will be able to sit at the same time to expeditiously handle cases filed in the Supreme Court, thereby reducing on the huge case backlog that exists in the Supreme Court. The Ministry of Justice and Constitutional Affairs and the Judiciary explained that currently there's a huge case backlog in courts of record, and further explained that case backlog in the Supreme Court, that's cases that have been in court for 2 and more years from the time of their registration, stands at 353 cases, and pending cases that have been in court for less than 2 years from the date of their registration, stands at 792 cases as at 31st October 2023. There's a table that shows the cases pending before the Supreme Court for the last financial years, and that is it. The Ministry of Justice and Constitutional Affairs and the Judiciary averred that the backlog at the Supreme Court requires more manpower to deliver justice to the people of Uganda effectively. Hence, the proposed amendment to the Judicature Act, Cap 13, in Section 3, to increase the number of justices of the Supreme Court as envisaged by Article 130 of the Constitution, hence the proposed amendment. The Minister of Justice, while appearing before the committee, considered that the proposed number in the bill was high. He proposed to the committee that the number can be reduced to 4 justices in addition to the current number of 11. The committee has examined the bill and presentations made on the matter and is of the considered opinion that the proposal to increase the number of justices of the Supreme Court from the current 11 to 21 be rejected. In arriving at this decision, the committee is of the opinion that instead of appointing additional justices of the Supreme Court, case backlog experienced at the Supreme Court can be dealt with through the following measures: A, appointment of justices at the Supreme Court in acting capacity under Article 142.2 of the Constitution. Article 142.1 of the Constitution empowers the President, acting on the advice of the Judicial Service Commission, to appoint judicial officers in courts of record. On the other hand, Article 142.2 also empowers the President, acting on the advice of the Judicial Service Commission, to appoint a person qualified for appointment as a Justice of the Supreme Court or Justice of the Court of Appeal or a Judge of the High Court, to act as such a Justice or Judge, even though that person has attained the age prescribed for retirement in respect of that office. Article 142.2 is intended to enable the President fill positions in the Supreme Court, Court of Appeal, and the High Court in situations where A, the office of a Justice of the Supreme Court or a Justice of Appeal or a Judge of the High Court is vacant. B, a Justice of the Supreme Court or a Justice of Appeal or a Judge of the High Court is for any reason unable to perform the functions of his or her office. C, the Chief Justice advises the Judicial Service Commission that the state of business in the Supreme Court, Court of Appeal, or High Court so requires. The committee is of the opinion that Article 142.2c can be invoked by the Chief Justice to appoint justices on the Supreme Court on temporary basis in order to deal with case backlog in the Supreme Court. The committee observes that it's cheaper and more efficient to appoint acting justices at the Supreme Court to deal with the issue of case backlog, since the acting justices are not entitled to retirement benefits, and once case backlog is cleared, then the appointment of such persons is revoked under Article 142.3 of the Constitution. This will therefore remove the need to appoint a high number of justices at the Supreme Court and alleviate the increased costs associated with increasing the number of justices as proposed in the bill. The committee is fortified in this opinion by the recommendation from the Judicial Service Commission, which also recommended that instead of increasing the number of justices of the Supreme Court as proposed in the bill, government should consider appointing justices on temporary basis as provided in Article 142(2)(c) of the Constitution. The Judicial Service Commission informed the committee that the President had in the past appointed judicial officers on temporary basis to deal with a specific need in the judiciary. This avenue has not been explored by government before proposing to increase the number of justices of the Supreme Court. The committee has also examined the issue of case backlog and is of the considered opinion that the solution for case backlog at the Supreme Court is not increasing the number of justices, but creating efficiency in case management and reviewing the jurisdiction of the Supreme Court so that the Supreme Court only handles matters of law, thereby reducing the matters that can be filed by the Supreme Court. B, review of the jurisdiction of the Supreme Court. The committee is aware that the jurisdiction of the Supreme Court is prescribed in Article 132 of the Constitution and Sections 4 and 5 of the Judicature Act. Under those provisions of law, the jurisdiction of the Supreme Court is as follows. A, the Supreme Court is the final court of appeal and handles appeals from decisions of the Court of Appeal while exercising its mandate, its appellate jurisdiction from decisions of the High Court or its original jurisdiction as a constitutional court. B, the Supreme Court has original jurisdiction in presidential petitions as prescribed in Article 1042. C, the Supreme Court also has criminal jurisdiction in the case of an offense punishable by a sentence of death on a matter of law or mixed law and fact, where 1, the Court of Appeal has confirmed a conviction and sentence of death passed by the High Court. 2, the High Court has acquitted an accused person, but the Court of Appeal has reversed that judgment and ordered the conviction of the accused. 3, where the High Court has convicted an accused person, but the Court of Appeal has reversed the conviction and ordered the acquittal of the accused. 4, where the Court of Appeal has confirmed the acquittal of an accused by the High Court. The committee is concerned that currently all manner of matters can be appealed to the Supreme Court, including matters of fact, which should ordinarily be handled by lower courts. This creates case backlog in the Supreme Court, since the number of cases that are filed exceed the capacity of the Supreme Court to dispense of them. The committee opines that the Supreme Court should only handle matters of law so that it can guide and set standards for lower courts on the application of such matters of law. The opinion of the committee is informed by the practice in most Commonwealth jurisdictions where the Superior Court in most countries only handles serious matters of law and in some cases only matters that the Supreme Court finds to be of great public importance. The table below shows the different countries and the jurisdiction of their Superior Court. In Kenya, under Article 163 of the Constitution, the Supreme Court has exclusive original jurisdiction to hear and determine disputes relating to the elections to the office of the President. Appeals can only be a matter of right. Where the case involves interpretation or application of the Constitution, or a matter certified by the Supreme Court or the Court of Appeal as one that involves a matter of general public importance. In South Africa, the Constitutional Court of South Africa is the highest court in South Africa, and it deals with matters of general public importance in addition to constitutional matters. In Nigeria, according to Section 230 and to 236 of the 1999 Constitution of Nigeria, the Supreme Court of Nigeria has original jurisdiction in any dispute between the Federation and a state or between states if and insofar as that dispute involves any question, whether of law or fact, on which the existence or extent of a legal right depends. The Supreme Court has no jurisdiction in criminal matters. In Ghana, Article 129 of the Constitution of Ghana 1992, the Supreme Court has jurisdiction in all matters relating to the enforcement or interpretation of the Constitution and all matters arising as to whether an enactment was made in excess of the powers conferred on Parliament or any other authority or person by law or under this Constitution. It also has appellate jurisdiction as follows. An appeal lies to the Supreme Court as of rights, in which a civil or criminal cause or matter in respect of which an appeal has been brought to the Court of Appeal from a judgment of the High Court or a regional tribunal in the exercise of its original jurisdiction or with the leave of the Court of Appeal in any other cause or matter where the case was commenced in a court lower than the High Court or a regional tribunal, and where the Court of Appeal is satisfied that the case involves a substantial question of law or is of public interest. There's also India the US, United States. I'll leave those for members to read. From the above table, it's evident that the jurisdiction of the Supreme Court is limited to the most serious cases, those involving constitutional interpretation, matters of law, and matters of great public importance. It's the opinion of the committee that instead of expanding the number of justices in the Supreme Court, the jurisdiction of the Supreme Court be reviewed in order to limit the cases that are filed at the Supreme Court. C, establish a court case sieving system at the Supreme Court. The committee is aware that due to the very jurisdiction of the Supreme Court, certain matters that end up at the Supreme Court should not ordinarily be filed with the Supreme Court. These matters include matters of law that had been settled by the Supreme Court, thereby creating case backlog. This is because there is currently no system to sieve out matters that can be handled by the Supreme Court in order to ensure that the matters are filed in the Supreme Court, and the matters that are filed in the Supreme Court are matters that deserving the attention of the Supreme Court. The committee is of the opinion that there is need to introduce a case sieving system at the Supreme Court to ensure that only matters of law and serious matters are referred to the Supreme Court, thereby weeding out matters that are not deserving to be heard by the Supreme Court. The committee is aware that a case sieving system is employed in a number of countries, including the USA and Denmark, and has been very instrumental in reducing frivolous and unnecessary cases that are filed in courts. The court sieving system ensures that only cases dealing with new and novel matters are entertained by the Supreme Court, so that the Supreme Court dedicates its time to serious matters of law. C, reviewing the pecuniary jurisdiction of magistrates' courts. The committee notes that currently courts of record in Uganda are experiencing high instances of case backlog. The high cases of case backlog in the courts of record is attributed mainly on the low pecuniary jurisdiction of magistrates' courts, which results in the filing of cases before courts of record, thereby creating backlog in the courts of record. Section 207 of the Magistrate Courts Act grants magistrates' courts pecuniary jurisdiction over matters of a value not exceeding 50 million shillings in the case of a chief magistrate and 20 million for magistrate grade 1. The stakeholders with whom the committee interacted recommended that there is urgent need to review and expand the pecuniary jurisdiction of the magistrates' courts to ensure that cases which are currently filed at the High Court can be disposed of at the magisterial level, thereby reducing the case backlog in the courts of record. The committee is concerned that even if the number of justices of the Supreme Court is increased, those measures will not be successful in dealing with the issue of case backlog in the Supreme Court, since the cases arising from the lower court will not be abated. It's the opinion of the committee that expanding the jurisdiction of magistrates' courts will therefore ease the workload of the courts of record and will release the courts to deal with the most deserving of cases instead of wasting time on matters which can easily be handled by the lower courts. D, appointment of court administrators. The committee is aware that judicial officers in Uganda exercise both administrative and judicial functions, which affect their productivity and efficient exercise of their judicial functions. For instance, the Chief Justice is the head of the judiciary, sits on the Judiciary Committee, while other justices of the Supreme Court serve as inspectors of court, represent the judiciary on administrative bodies, are appointed by the President to serve on other institutions of government and courts in other jurisdictions and international bodies, and also perform many functions in addition to their judicial work, including human resource management, fiscal administration, case flow management, technology management, information management, jury management, space management, intergovernmental liaison, community relations, research and advisory services, and secretariat services. The appointment, secondment, and assignment of judicial officers to other international bodies and jurisdictions, as well as the grant of administrative functions to justices of the Supreme Court and Court of Appeal, takes away from those courts valuable members and denies the court the efficient and timely exercise of its functions, thereby affecting its productivity and creating case backlog. The committee is of the considered opinion that judicial officers, especially in the courts of record, should not be allowed administrative functions or allowed to take up paid positions in other jurisdictions in order to ensure that they dedicate their time to dealing with judicial work. E, introduction of performance management system. Section 18 of the Administration of Judiciary Act 220 provides for the establishment of a performance management system. The performance management system is intended to track and manage the performance of all judicial officers in a manner that's consistent and measurable to determine if they are productive and are contributing to the strategic objectives of the judiciary. The performance management system would provide empirical information to inform government on the optimal number of judicial officers at all levels and would give credence to the proposals made in the bill. The committee notes that the performance management system has not been established in the judiciary, making it impossible for the committee to decide on the optimal number of judicial officers across the entire judiciary, especially those in the Supreme Court. The lack of a performance management system makes it impossible to measure the output of the judiciary, making all measures to deal with case backlog impossible to measure their effectiveness. The committee has also considered the practical and legal implications of the proposal to increase the number of justices of the Supreme Court and finds that the proposal is not properly conceptualized. For instance, the committee is concerned that increasing the number of justices of the Supreme Court will increase government expenditure. The committee is aware that whereas government issued a certificate of financial implications, the certificate doesn't take into account the additional costs required to make additional justices effective in executing their mandates. The committee is aware that a justice of the Supreme Court is entitled to certain facilities, including bodyguards, research officers, house helps, and other persons who facilitate the justices to deliver on his or her mandate. These persons are paid from the consolidated fund, since they are either staff of the judiciary service or public officers employed through the relevant laws. The costs associated with employing and paying the persons providing services to facilitate the additional justices were not considered, yet they are astronomical and will burden the taxpayer. In addition, the committee is also concerned that whereas there is an increment in the justices of the Supreme Court, the other agencies that facilitate the judicial officers, such as state attorneys from the office of the DPP and the Attorney General's office, who must attend court to prosecute matters before the Supreme Court, are not planned for recruitment. This will make justices of the Supreme Court redundant and effective to deal with case backlog, since they will lack professionals to prosecute matters before the court. The proposal to increase the justices of the Supreme Court from 11 to 21 is not an international best practice and is not optimal for a country like Uganda with a small population and constrained GDP. The committee is aware that globally there is correlation between the number of justices and of the highest court and the population density of the country and the country's GDP. The table below explains the matter in details. I ask members to look at it. Uganda, for example, the population is 48 million. Of Supreme Court judges 11. The ratio is 1 to 4,300,000. And you continue looking at the others. The committee observes that on average, the most Commonwealth countries have an average of 10 justices of the Supreme Court. The table also indicates that on average, the ratio of population to the justices is 1 to 5 million people. Currently, the ratio of Supreme Court justices to the population stands at 1 to 4,300,000 people, well within the global average. The committee therefore finds that the number of justices should be left at 11, since that number is an international best practice. The committee is also concerned that the justification given by the Ministry of Justice and the Judiciary for expanding the number of justices, being the need to have 3 panels at the Supreme Court, will pose practical and constitutional challenges and may hinder the development of jurisprudence in Uganda. The committee notes that the Constitution in Article 132(1) directs the Supreme Court to be the final court of appeal and is indeed the superior court in Uganda in all matters. The committee is aware that Article 132(4) of the Constitution directs that decisions of the Supreme Court have a binding effect on all courts in Uganda, save that the Supreme Court can depart from its earlier decisions on a matter. The committee is concerned that the proposal to have more than 1 panel at the Supreme Court will result in decisions that may conflict on the same matter, since the composition of each panel will be different. This will affect the court users, since those conflicting decisions cannot be corrected by any other court owing to the fact that the Supreme Court is the highest court in Uganda, thereby affecting the development of jurisprudence. The committee is also concerned that it is impractical to have more than 1 panel at the Supreme Court, since Article 131(3) of the Constitution directs that the Chief Justice is to preside over the sittings of the Supreme Court, except in his or her absence, that the sitting is presided over by the most senior judge. The committee is of the considered opinion that the proposal to have 3 panels at the Supreme Court needs to be reviewed due to its practical and constitutional ramifications. The Constitution is also aware, the committee is also aware that in 2015, the then Chief Justice, Honorable Justice Bat M. Katurebe, instituted a committee to, among others, identify the extent of case backlog in the judiciary, identify and document the causes of the backlog, review current efforts to reduce the case backlog, and make recommendations to address the existing backlog and stop the growth of a new backlog. The committee was composed of Honorable Justice Richard Butera, Honorable Justice Efe Gondantende, Honorable Justice Dr. E. Chitimbo Chisache, Honorable Justice Geoffrey Chiriabwire, Honorable Justice Mike Chibita, Honorable Justice Stephen Musota, Honorable Justice Dr. Henry Peter Adonyo, His Worship Paul Gadenya, Mr. Kagole Expedito Chivumbi, Mr. Francis Gimara, Mr. Sam Rogers Wairagala, and Mr. Andrew Kauka. The committee made the following recommendations as far as case backlog is concerned. 1, maximize time spent in court. Stakeholders recommended that judges should spend their time more in the courtrooms, stroke chambers, handling cases. As such, any events which take judges out of the court should happen in a specific season to avoid disrupting the ordinary work of court. 2, improve performance of judicial officers and officers of court. It was recommended that attendance by judicial officers and officers of court must be strictly monitored and work ethic improved. The judiciary should put in place a system of rewards and sanctions, e.g., judicial officers who have not cleared their backlog should not be promoted. A reward might be in the form of a plaque recognizing the achievement made to the institution or different individuals involved. 3, staffing and placement. More judges be appointed and judges should be allocated with more reference to their area of expertise. Judges should not be transferred at short notice to avoid leaving part-hard cases. 4, jurisdiction. Expand the jurisdiction of the magistrates' courts so that they can handle more cases. The committee was not updated on how far the above-cited recommendations have been implemented by the judiciary in order to assess their effectiveness and form a basis for increasing the number of justices of the Supreme Court. During the consultations, the committee also undertook a comparative study from other jurisdictions on the issue of case backlog with the intention of getting best practices to inform the committee recommendations. Many other jurisdictions have implemented measures that have reduced case backlog and increased efficiency. For example, in Kenya, a court census was carried out in 2013, and it resulted in the development of a case backlog reduction program, including 1, setting targets for magistrates, 2, the implementation of a judiciary performance management system so that the efficiency and workload of each judge... Pardon?
There's a motion.
Thank you, Right Honourable Speaker. I want to duly appreciate the chairperson for a very elaborate report, which is very, very clear. And as a legal mind, I cannot forget my first year introducing law, jurisprudence. Right Honourable Speaker, given the fact that this is a very simple amendment, I would like to move a motion under Rule 59 that the chairperson goes to the next level. We go to committee stage and deal with it, and then deal with other urgent matters. The bill is very clear and it's not controversial. Right Honourable Speaker, I beg to move.
Is he seconded? Seconded by Honorable Senyonyi. Even the one-man leader of Jema, Nakawa, the landlord Rubaga, by Malende, the landlady, by the LOP, by the whole opposition. All opposition. Honorable members, you've had the motion that has been moved. And honorable members, whereas Rule 204 4B indeed provides that once a report is submitted, it is given 3 days. This matter is about justice. Justice delayed is justice denied. So I want to invoke Rule 7 and the precedents that have already been set on us going ahead with this. Honorable members, since a motion has passed, I now put a question that the Judicature Amendment Bill 2023 be read for the second time. Those in favor say on the contrary, nay. The ayes have it.
The Judicature Amendment Bill 2023, Bills Committee stage. Clause 1.
Honorable members, proceed at committee stage. Let me hear from the Shadow Attorney General first. We're in serious matters now.
Madam Chair, I have not seen anything requiring a procedure point.
Thank you, thank you.
Clause 1.
Clause 1, Chair. Chair.
Clause 1, amendment of the Judicature Act, Cap 13. Delete Clause 1. Justification, increasing the number of justices of the Supreme Court from 11 to 21 will not solve case backlog in the Supreme Court, since case backlog is caused not by lack of justices of the Supreme Court, but by other matters including inefficiency, poor case management, and the jurisdiction of the Supreme Court, which allows every matter to be referred to the Supreme Court. Increasing the justices of the Supreme Court will result in a bloated bench, deter easy and efficient decision-making, and will increase the burden of the taxpayer. Reviewing the jurisdiction of the Supreme Court, High Court, and Magistrates' Courts will result in a reduction in case backlog in the entire judiciary and reap more benefits than increasing the number of justices of the Supreme Court.
Honorable Minister. Honorable Minister. Honorable Minister.
Madam Chairperson, on Monday we had a very...
Honorable Minister, is that okay with you or not?
The government disagrees with the recommendation of the committee.
What does government want?
Madam Chairperson, I thought we had reached a middle ground of 15 justices of the Supreme Court. We reduced the number from what we had requested, and we made some undertakings, namely that we are committed to access to justice 360 degrees. So the committee should have come to this House and also reported our undertakings and also the efforts that we reported to the committee, namely that we have enhanced the numbers at DPP, we have enhanced the numbers in the state attorneys, in the Attorney General's chambers by hiring more state attorneys. We have also introduced alternative dispute resolution, including plea bargaining to clear backlog in criminal cases. We are introducing mediation, arbitration, and conciliation. We have also agreed to draw clear boundaries for the work of the Supreme Court so that the Supreme Court is not bogged down adjudicating factual disputes, but to restrict itself to matters of law, which is what we know the Supreme Court is supposed to do. These are undertakings we made. We even went into a closed session with the committee. Madam Chairperson, I feel stabbed in the back by the committee because I thought we had reached an undertaking, and we are now appealing to the whole House to overrule the committee.
Honorable, the committee has not stabbed you at all. What the committee is saying, they propose that the Chief Justice will be given powers under Article 142, where we can be getting justices on acting capacities. And that is cheaper, because it is easier for you to look after the justices on an acting capacity than the ones on permanent who are not working, who are on holiday. Yes?
wanted to show the Minister that we actually were open to the House. On page 6, we said the Minister of Justice, while appearing before the committee, considered that the proposed number in the bill was high. He proposed to the committee that the number be reduced to 4, in addition to the current number of 11. But for us, the next goes on to say the committee has examined the bill and presentations made on the matter and is of the considered opinion that the proposal to increase the number of justices of the Supreme Court from the current 11 to 21 be rejected. So, Honorable Minister, we mentioned what you had said, but we didn't agree with you. Thank you.
Thank you, thank you.
I just wanted to inform the minister, we did pass the Judicature Amendment Act in 2008, increased the number of justices of the Supreme Court to 11. But since then up to now, they have never appointed the 11. There are only 9 that have been appointed. So appoint up to 11.
Honorable Katuntu.
Thank you very much, Madam Chairperson.
We are not going to waste a lot of time on this. For me, it is a very simple thing. It's just a matter of putting a question. You get it, eh? Let's put a question and we see. Honorable members, I put a question that clause 1 be deleted as proposed by the committee. Those in favor say on the contrary, nay. The ayes have it.
Clause 2.
Clause 2.
For clause 2, they substituted the following. 2, substitution of section 9 of the Principal Act. The Principal Act is amended by substituting for section 9 the following. 9, the Court of Appeal shall consist of the Deputy Chief Justice and 29 justices of the Court of Appeal. The justification is that in light of the need to create a panel of 5 justices in each of the regions of Uganda, which currently do not have permanent courts of appeal, constitutional courts, to increase the number of justices of Court of Appeal, constitutional court from 15, including the Deputy Chief Justice, to 30 justices, including the Deputy Chief Justice. Currently, the law provides for 14 plus the Deputy Chief Justice, making them 15. Then we considered the other regions that traditionally don't have courts of appeal, Northern, Western, and Eastern. And we said let's have 5 judges in each. Those come to 15. When you add the current 15 here, under the Constitution, those come to 30. That's how we got to that.
29. See, 29 plus 1, 30, okay. Honorable Minister.
Madam Chairperson, justice is done in the name of the people and for the people. We are dealing with the practical problems, not matters of theories. We are proposing to have up to 9 circuits, and that is why we put the number at 56. And I thought the committee had agreed. So government disagrees with the position of the committee. Madam Chairperson, we have had some rapid consultations on the front bench, and I know that the Parliament is still here, And should there be need, we shall still be back. But I would still beg this House to add 5 more to the proposed 30. I think a spirit of give and take is healthy because I am the one dealing with the people who are waiting for their appeal cases to be heard. And the practical matter I'm dealing with is the health of many of the Court of Appeal judges and the backlog which ties them down to carry out more research and to write judgments, which means the panels cannot be constituted at the same time. I ask that members add 5 to the 30 proposed by the committee. I beg to move.
Honorable members, let's have a win-win situation. You know, at the end of the day, it is all of us that end up in court during election petition. They will not be hearing to our appeals. He is requesting for additional 5.
Right Honourable Speaker, maybe our chairperson may have a second.
Madam Chair, I concede.
But will you appoint them? The question is, will you appoint, because the 11, you've not appointed all of them. First assure us that they are going to be appointed.
The current law provides for 15 in the Court of Appeal, but only 12 have been appointed since 2008. So will you appoint even the 35 when you failed to appoint the 15?
Madam Chairperson, first I would like to thank most sincerely the chairperson of the committee for this important concession. I also want to thank you, Madam Chairperson, for filling the vacancy which was in the Judicial Service Commission. Now that the Judicial Service Commission is fully functional, we promise that these appointments shall be made, and there are enough Ugandans who are qualified, including some among you who may be considering career moves.
Thank you, thank you. Honorable members, I put a question that clause 2 be amended as proposed by the Honorable Minister of Constitutional Affairs and amended by and considered by the chairperson of the committee. Those in favor say on the contrary, nay. The ayes have it.
Clause 2 as amended.
I put a question that clause 2 as amended stands part of the committee. Those in favor say on the contrary, nay. The ayes have it.
Title.
I put a question that the title stands part of the committee. Those in favor say on the contrary, nay. I put a question that the title stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Motion for resumption of the House. The Committee of the Whole House.
Honorable Minister.
Madam Speaker and honorable members, I move that the report from the Committee of the Whole House be adopted. I beg to move.
I put a question that the House adopts the report of the Committee of the Whole House. Those in favor say on the contrary, nay. The ayes have it.
Bill's third reading, the Judicature Amendment Bill 2023.
Honorable Minister.
Right Honorable Speaker and honorable members, I move that the bill entitled the Judicature Amendment Bill 2023 be read a third time and do pass. I beg to move.
Thank you, Honorable Minister. The quorum we have virtually 62 and fiscal 181. So we have the quorum. I put a question that the Judicature Amendment Bill 2023 be read a third time and do pass. Those in favor say on the contrary, nay. The ayes have it.
A bill for an act titled the Judicature Amendment Act 2023.
Bill passed and settled. Thank you. Next item.
Item 6, statement by Minister on alleged enforced disappearances of persons.
Honorable members, as I guided yesterday, today we will receive a response by the executive to the concerns raised by the leader of opposition in Parliament regarding the enforcement of disappearances of persons and other human rights related matters. This is in fulfillment of the directive of the presiding officer then on 19th October 2023. The minister was supposed to bring a statement on 19th, which fell on a weekend. They were now supposed to come back on 21st, and they wrote to my office asking for an extension for 1 week. And today, the minister has informed us that he's ready. And because the minister has given us the document, which has been duly uploaded, can we now listen, attentively listen to the minister? Honorable Minister,